Our democracy is founded upon the unquestioned, unchallenged sovereignty of the people. The monarch swears to protect our liberties without exception. If anyone tells you that our constitution, founded upon Magna Carta 1215, has been set aside or superseded, is simply and profoundly wrong. Here's the thing, and here's how we win the war. Either we live in a democracy in the form of a constitutional monarchy, or we don't. If we don't, then Parliament better at least have the decency to tell us so, and furthermore to explain when and how that happened. We are free people and sovereign. We're not granted that freedom by Parliament, but by the bedrock of our Constitution, indeed by the universe itself. That Constitution is much older than Magna Carta, which was only a 1215 restatement of what was already true and understood and made real by the much older common law. I've said this before, and I'll keep saying it until the silence is overwhelmed and we begin the long task of remembering that we cannot be told what to do by government.
What exactly is Neil Oliver talking about? As we will see, the idea of natural law is rooted in the notion of the two laws, one resting on human authority, the other claiming divine or natural origin, and therefore entitled to supremacy over mere human law. Understand the entire chronicle of the philosophy of law can be summarized as an endless argument between two major theories or collection of theories. One, legal positivism, which I will deal with in a later episode. And two, which is what I think Neil's talking about, natural law. In other words, the landscape Mr. Oliver has delved into is exceedingly complex and ever-changing, which is kind of funny when we're talking about natural law. But in a nutshell, whereas positivism looks at what lawyers actually say and do to make rules or laws in order to identify and explain the concept of law, natural legal philosophers or lawyers, from ancient times to the present, rely on the capacity of human nature and human reason to understand the mind of God, or perhaps the mystical mind of the universe, or such concepts as the will of the people, to identify laws applicable to man, and thus to know what needs to be done. Positivism tries not to concern itself too much with morality, although that is actually impossible, whereas natural lawyers are unashamedly concerned with right and wrong, with an emphasis on the ethical necessity of law. To jump ahead a bit, say 10,000 years, perhaps what Neil Oliver is referring to, I think, is the Enlightenment idea, Jean-Jacques Rousseau's notion of natural law, that it conferred an absolute and inalienable authority on the people as a whole, perhaps reflected or seeping through the Magna Carta. As I've already mentioned, this notion of a social contract is correctly regarded as a fiction. There was never a time when men wandered about on their own in the woods, looking to form a bargain with other individuals, and thus forming communities. That never happened. Reality is more complicated, but we will get back to Rousseau and the modern natural law thinkers in part 2. This is a really big topic. In part 1, we're going to look at the classical origins of natural law. As best we can tell, the earliest associations of men did not clearly distinguish between the natural world, animate or inanimate, and the world of human beings. The gods and spirits directed all of nature, which included governing the affairs of men on earth. There was no distinction between what we would call physical laws of nature and the divine laws that governed human society. Nature was bound by divine law, but not in a Newtonian or deist sense, like a wound-up clock that has predictable and repeatable motions. The sun may have risen every morning, but that didn't mean it would rise again tomorrow, or the day after that, or the day after that. The gods and spirits who run the world can change their minds if you skip those sacrifices, and the sun may not rise, leaving the world in darkness. What is important to understand is that there is no conception of the divine lawmaker in these early societies. Even the ancient Chinese, who made incredible leaps forward in their civilization and culture, did not, according to Lloyd, develop the notion of a personal divine lawmaker. They relied on harmony as a governing principle. Justice and harmony could be preserved if the appropriate rituals and customs were followed, much like our Mayan friends we just saw going about their business. Natural law, as we understand it, really seems to take off with the waning of the animistic and polytheistic age in Europe and elsewhere around the globe, and the rise of what we may call the age of man, or the age of monotheism.
The days of our kind are numbered, Ed. The one God comes to drive out the many gods. The spirits of wood and stream grow silent. It's the way of things, yes. It's a time for men and their ways.
Rather than a world of capricious gods making capricious laws, philosophers and prophets began to envisage a world of fixed divine rules, capable of being ascertained and understood. Consider the Hebrews, for example, and the Ten Commandments. Natural law is really often running with the pre-Socratic philosophers, whose main stated objective was to explore the world of nature in order to discover the laws governing the natural world and the world of men. Introduced to the scene is the belief in the power of reason. Rationalism, as it's called, is the belief that the universe is governed by ascertainable laws, capable of being grasped through observation and reflection. Religions like Catholicism to this day believe that man, freed from the clutter of sin and his enslaving vices, can fully access, through his will and the power of reason, the divine logos, which runs the world. By living naturally, so to speak, he has a good chance at having a government that makes good and just laws on earth, and will find himself living in peace and harmony in his community, with eternal life as an added bonus. But right out of the gate, natural lawyers had the problem of how to determine what is natural for man. It might not be good to steal, but since men did steal, did that mean stealing, raping, and pillaging were natural? Was a just law one that restrained these impulses? The Greeks noted also that the laws of men differed dramatically, not only between distant civilizations like China, but also between nearby cities like Athens and Sparta. An essential divide in the approach to natural law comes with the writings of Plato and Aristotle. Reduced to its bare bones, Plato regarded natural law as an ideal, which could only be properly ascertained by a philosopher king and enforced through a kind of dictatorship. As Lloyd writes, Plato's static view of justice, like that of most utopians, involved a totalitarian conception of law and government of the most rigid and inflexible kind. A question for another day is whether woke or progressivism, which seems to reject natural law, is actually a manifestation of the Platonic version or the Platonic conception of natural law, including a propensity for oppression and tyranny in pursuit of an ideal. Aristotle, by contrast, rejected Plato's idealistic spirit and replaced it with an empirical one, relying on observation and experience. Again, is modern censorship of dissenting scientific views a form of Platonic idealism imposing itself on those irritating empiricists? At any rate, Aristotle concluded that justice can be conventional, varying from state to state, based on history, the needs of the people, and tradition, or natural, common to all mankind, or at least, from his perspective, all men in the various Greek city-states. As for foreigners, well, Aristotle thought some are just born to be slaves. We can see here two divergent attitudes to natural law that are still competing to this day among modern natural law thinkers and theorists, as well as knuckle-dragging progressives. Is law an ideal to aspire to, appreciating that human societies almost always fail to meet the ideal? Or to quote Lloyd, On the other hand, nature may be regarded as simply the way man behaves by reason of his psycho-physical makeup. Yet at the same time, even the second view contains implicitly a normative element, because in examining man's actual behavior, some standard will inevitably have to be applied in order to decide what is natural and what is non-natural. Natural law as a universal system applicable to all people reaches full form with the collapse of the power of the independent Greek city-states and the subsequent conquests of Alexander. As societies merge, by conquest or otherwise, the idea of cross-societal universal truths becomes more comprehensible. Also, centuries later, with the Roman expansion, we see introduced the notion of the lex gentium, or the law applicable to both Romans and foreigners. Really, one could say, the beginning of an international law. Two competing philosophies emerge around this time: Epicureanism, which has more in common with utilitarian positivism, and today's subject, Stoicism, which had a significant influence on natural law thinking. Stoicism stressed the universality of human nature, which blended nicely with Christianity's universalism. We can also see the influence of the Stoics in the modern concepts like the rights of man during the Enlightenment, or the post-World War II international world order, as clumsy and as ill-fitting as this universalism has become. Julia J. A. Shaw writes, "Arguably the most important philosophy in Rome was Stoicism, which originated in Hellenistic Greece. The Stoic legacy has been instrumental in setting out the basis for early natural law. Essentially, following the logic of Aristotle, the Stoics believed in a world governed by chance and necessity, free from divine or human interference, leaving humans in a state of nature. In this non-hierarchical world of possibility, the origin of knowledge and criterion of truth, accessed by the mind through the senses, could only be attained by reason, which was considered to be an innate ability common to all people." Artistic license aside, listen to Alec Guinness as Marcus Aurelius in The Fall of the Roman Empire, as he and the script writers do a decent job capturing the spirit of the Stoic mind.
Think of all you have read and pondered over the years. And the talk, Marcus Aurelius, the hours of talk with your friend Timonides. Surely it must have prepared you for this moment. But it has failed you, hasn't it? You are not prepared.
Why?
In all that talk, did this topic, death, slip your minds? Or did you know, deep down, that your wisdom would be helpless before this mystery of mysteries? But once you admit that, all other knowledge and skill becomes trivial and meaningless. But then you would not have thought and read and talked and wondered.
So perhaps it's just as well.
For if men do not think, read, talk to each other, above all else, talk, they are no longer men. I've always been willing to bargain with my enemies. Can we not make a treaty? For your part, I ask you to wait 2 years.
1 year. I cannot do it in less than a year.
I do not seek pleasures or friendship or love.
I speak only of Rome. And when I say Rome, I mean the world.
Roman lawyers didn't have to deal with the masses of ever-changing laws and regulations that clog the arteries of the modern state, nor with the laws of the Roman Republic and early empire as they were codified and organized. In many ways, Roman law was like early common law in Norman England, decided case by case. The flexibility of Roman law meant that any settled rules and principles had to be interpreted in the light of equity so as to apply them to the particular circumstances of the case. Roman lawyers in the Republic, and again the early empire, had to use their rhetorical and analytical skills to make compromises, taking into account inconsistent rules, competing aims, and authoritative texts, and new situations. There were few settled rules and procedures to fall back on that could be tailored effortlessly to the case before them. As Shaw writes, in the cause of justice, moral principles were held to be capable of explaining legal rules and deciding contested legal issues, as these can be derived from the innate human capabilities of intelligence and reason. The Emperor Justinian earned his place in the history of law by codifying and organizing the scattered works of the classical Roman jurists. Justinian's 6th century Digest records what the classical Roman jurist Ulpian had to say about the law. Law, said Ulpian, related to 4 elements, or what we might call sources: art, religion, ethics, and philosophy. Ulpian described the study of law as the acquisition of the knowledge of things divine and human, and the science of what is just or unjust. As we saw when we looked at law and morality, many laws today are still clearly rooted in morality, such as laws against murder or robbery. A harsh punishment like crucifixion in Roman times would be considered moral if the penalty was justified by the seriousness of the offense. A law releasing a suspected rapist due to a technical violation of his human rights would have been considered absurd to a Roman jurist, as natural laws focused on substantive justice. Ulpian likened lawyers to priests, well versed in the art of inquiry into the good and just. The ancient Romans introduced many criteria as to what a true law should look like, if indeed it is a true law. I would argue we can find this recapitulated by Lon Fuller in what he called law's inner morality. A rule of law has to be, for example, comprehensible to natural reason. It has to allow for reasonable exceptions, like self-defense. And a true law can't compel what is impossible. For example, Ulpian would also certainly have opined that a law permitting a man to marry a man was not a law, nor was a law allowing a woman to declare herself to be a man. In either case, such laws ran contrary to nature, properly understood by the unimpaired mind applying sound and sober reasoning. Conclusions: such laws being utterly absurd or impossible are not true laws, and can be disobeyed, or have no force and effect. Natural law has embedded within it state restraint. Unlike positivism, Roman law, and indeed the Roman Republic and Empire, existed under a minimalist legal regime, the exact opposite of the modern total state. Echoing the concept of subsidiarity in Catholic philosophy, natural law, at least the Roman variety, discouraged state meddling in the minutiae of people's lives. This seems counterintuitive, as Rome was supposedly a vast, mighty, militaristic, and oppressive slave empire. To say Rome was legally minimalist doesn't mean Romans were nice. It doesn't mean they weren't ruthless in dealing with their enemies, including using slavery to maintain their standard of living in a world without machines. But Roman men in their full capacity who didn't make a nuisance of themselves, like the Druids or Christians were seen to have done on occasion, were much more free of state meddling than our modern equivalents of whatever gender or caste. Roman statesman Cicero, who had his hands nailed to the doors of the Senate by Mark Antony, did, in better times, make important contributions to natural law theory. Cicero described natural law as the true law, a sentiment we hear echoed in the voice of those dissenting to woke laws today. As Shaw writes, Cicero suggested 3 distinguishing features of natural law. It is a manifestation of the divine will and is consequently universal, eternal, and unalterable. 2, its rules must be discovered through the application of reason. And 3, all persons are obliged to obey these rules. Consider the following when you consider the modern West, and what passes for the good, the just, and the fair under the influence of progressive laws. To Cicero, any breach of natural law was a violation of one's true nature. A society living contrary to natural law would be a society in which citizens have, in quotes, abandoned their better selves. Such a person, or such a society as a whole, cannot live in a state of peaceful harmony and justice, which seems to echo ancient Chinese philosophy. Another way of looking at it, a society living contrary to natural law or contrary to nature will manifest itself as violent, chaotic, disordered, arbitrary, even vindictive, and most certainly unjust. You can judge for yourself. Next time, natural law from Thomas Aquinas to modern times.